Good afternoon and evening, everyone. Thank you for joining us today for this important webinar, Duty to Protect, Duty to Respect, Addressing Risk of Forced Labor and Human Trafficking in UK Horticulture. My name is Marcia Guerra. I'm a Brazilian lawyer and Fundación Libera's Executive Director. I am honored to be your host for this session. Before handing over to our moderator, I would like to highlight a few key points. As host, we will be sharing links and resources in chat as the panelists make their remarks. As the webinar progresses, you can submit your questions in real time through the chat. The Q&A session will take place to the end of the webinar in 1.5 hours, approx. To increase likelihood to your question being addressed, we recommend submit it well before the Q&A segment begins. The Q&A for our guest of honor, Mr. Obokata, special reports will be asked immediately after his presentation. And lastly, this webinar is being recorded and will be shared live through the Facebook. James Fox will be our moderator. James Fox is the UK and European manager at the Anti-Slavery International and chair of the Anti-Trafficking Monitoring Group. He focused on the rights of survivors of trafficking and forced labor in UK, especially matters concerned to assess, to support, protection, justice, and entitlements. James has specific experience working closely on the issues related to non-punishment principles, the relationship between migration and exploitation, and the European Convention on the Action Against Trafficking. He represented Slavery International with European partners. James, the floor is yours.
Thank you very much, Marcia, for the introduction, and welcome everyone. I'm very happy to be moderating this session today. And I'll just do a quick introduction to the session and the issues that we'll be discussing, and then I'll pass over to our guest of honor, Mr. Obokata, for his talk. So, by way of background, I think it's important to understand the seasonal worker scheme. So in 2019, the UK piloted the seasonal worker scheme, and despite clear risks of exploitation being identified, it was expanded and rolled out fully, and has most recently been given a 5-year extension by the Department for Environment, which means that next year there'll be 43,000 visas available for people from across the world to come and work in the UK horticulture sector. Despite continuous warnings and evidence and many people making noise about the quite obvious evidence of risks of exploitation and abuse in the scheme, very little, if anything, has been done to tackle this widespread exploitation. And then on June 3rd, the UN Special Procedures issued a press release expressing their alarm at what they call the systemic exposure of migrant workers in the UK to protection risks related to deception, exorbitant recruitment fees, debt bondage, undignified living conditions, and potential deportation and detention in the UK. This communication pertains to the complaint that was sent last year by civil society organizations, specifically concerning the case of Latin Americans who were recruited in Chile and transferred to agricultural fields in England, and were therefore subject to that risk of forced labor. Over the past years, several journalists, including the Bureau of Investigative Journalism, who've done a lot of work on this, have uncovered how the UK's seasonal worker visa is riddled with abuse and exploitation. And this conversation hopes to delve into the extent of this and the scope of the state's duty to protect, the business's duty to respect human rights in the face of the UN Special Procedures communication to the UK government and the businesses involved, and also hopes to hear from on-the-ground practitioners and human rights experts about all of the problems that are going on and hopefully some of the solutions that we have to tackle this abuse. We want to expand on the measures needed to address and prevent forced labour and human trafficking in the UK horticultural sector and emphasise the importance of robust regulatory frameworks, effective enforcement, corporate accountability, the protection of vulnerable workers, and reform and review of the use of restricted visas in UK, which tie people to employers and often tie them into situations of exploitation. So, without keeping any further, I'm very delighted to introduce Mr. Tomoya Obagata to the Special Rapporteur from the UN. Mr. Obagata is a Japanese scholar of international law and human rights, specializing in transnational organized crime, human trafficking, and modern slavery. He was appointed the Special Rapporteur on Contemporary Forms of Slavery, including its causes and consequences, in March 2020. He is currently the Professor of International Human Rights Law at York Law School and has previously taught at Keele University, Queen's University Belfast, and the University of Dundee, all in the United Kingdom and Great Britain and Northern Ireland. He has extensive experience working on issues of transnational crime, human trafficking, and modern slavery with relevant stakeholders such as the UK Joint Committee on Human Rights, the All-Party Group on Human Trafficking of the Northern Ireland Assembly, the United Nations Office on Drugs and Crime, the International Organization for Migration, and the European Union. Mr. Obagata has also worked as a legal assistant for the United Nations High Commissioner for Refugees in Japan, and he has published extensively on the aforementioned topics. And he'll be here to make remarks and talk about the communication that was sent to the government on the 3rd of June. So, Mr. Obagata, please take it away. Thank you very much, Marcia, for the introduction, and welcome everyone. I'm very happy to be.
Well, thank you very much for that introduction. And hello, good morning, good afternoon, good evening, wherever you are. I am Tomoya Obokata, the current UN Special Rapporteur on Contemporary Forms of Slavery. Now, before going into the specific UK communications that I led, I thought I would explain what I do in my role, just in case many of you may not know what these special procedures are. Now, I was, as has been stated by James, appointed back in 2020 on this role, and I do deal with issues which include traditional slavery, which still exists in certain parts of the world, such as in the Sahel region of Africa, forced and child labor, child marriage and forced and child marriage, and as well as sexual exploitation of individuals and so on. And one of the key functions of my role is fact finding. And for that purpose, I produce annual reports on particular theme every year to the UN General Assembly as well as the Human Rights Council. So for example, this year, I'm looking at the role of trade unions, workers' organizations in addressing modern slavery as one of the themes. And the next thing I do in fact finding is to go into the field and I conduct country visits. So in the past, I have visited Sri Lanka, Mauritania, Costa Rica, Canada, and so on. I am going to go to Australia later this year. And one of the, every time I'm going to these countries, and obviously I looked at the condition of migrant workers in respective countries because that is a key issue. And that protection of migrant worker is of an utmost concern for me in various jurisdictions. And finally, when I receive allegations of contemporary forms of slavery in various parts of the world, I respond to those allegations by communicating with the governments concerned as well as companies which may be implicated for engaging in, for example, debt bondage and forced and child labor and so on. This is in order to facilitate communications and then encouraging all stakeholders to take actions if these allegations are true. So in that context, then I have been receiving information about the seasonal workers scheme in the United Kingdom, and particularly involving in this on this occasion workers, mainly workers from Latin American countries such as Chile and Bolivia and so on. And I received an allegations all of debt bondage. For example, debt bondage happens when workers have to repay their debt in order, many of them do incur a large amount of debt coming into a country like United Kingdom, and some of the allegations I received are exactly that, because they have to pay a large sum of money to the recruitment agents and so on. And by the time they arrive and they are in debt, and at the end of the day, they are not making money or saving money. They are simply here in this country, UK, to repay their debt. And so that creates a vicious cycle of exploitation and abuse, and the power relationship that has between employers and employees may amount certainly to servitude, and in worst cases, slavery, the worst form of exploitation under international labor and human rights standards. So I received the information, and the communications that are now available on our website. And although the names of individuals concerned are concealed for obvious reasons, and I was certainly dismayed by these allegations. First of all, for working conditions, I have just read the report, the most recent report by Flex, which I think would like to first of all congratulate the team for that excellent report. And it is this kind of report that I need for fact finding, and I look forward to collaborating with all the relevant colleagues in the future. And what they said and what I have kind of found are pretty much similar in terms of working conditions. For example, long working hours without breaks or rest and leisure, and underpayment with the holding of wages, threats, harassment for in case of female workers, and harassment or threat of sexual nature. And that also extends to living conditions. They may have to live in a very crowded caravan, for example, with little access to, insufficient access to electricity, water, and so on. And the living conditions are not sanitary, have to share with a large number of individuals, and so on. And now it is obviously difficult to argue that every single farmer is like that. Then I think we need more extensive research on it, but it doesn't really matter from my point of view. Even one victim is sufficient enough for me to take an action and intervene. And thanks to those colleagues in journalism and civil society organizations, I was able to send that communication together with my colleagues. We also have colleagues such as Special Rapporteur on Human Trafficking, Special Rapporteur on Migrants, and the Working Group on Business and Human Rights. And now, I sent the communication to the UK government as well as Haygrove, which is a farmer, and also a Fruitful job, which is a scheme operator in charge of recruiting these workers in various parts of the world, and they have replied. And obviously, many of these replies are quite standard, and whether they are mainly stating they are in compliance with the UK, laws and regulations. In the case of UK, they also, have these schemes in place. But it is obviously under international human rights and labor law, United Kingdom is clear legal obligation to protect workers and provide assistance to victims of exploitation and abuse. But according to the information allegation I received, that is not happening. The identification of these instances seems to be quite sporadic. That tells me that the labor inspection regime must improve, first and foremost, and by the relevant authorities, such as, again, Masters Licensing Authority and other law enforcement, and so on. And yes, there is, as you might know, there's a so-called national referral mechanisms where the victims can approach various entities to seek protection from the UK government. And that system has been in place for some time. And it is gradually improving, I would say, compared to so many years ago when it was first instituted. But again, there are certain issues that I have expressed some concerns about the operation of the national referral mechanism in the past. And although I do acknowledge that improvements are being made, I think more needs to be done to properly identify and provide protection. And the protection should not be contingent upon cooperation with law enforcement authorities. and that has happened in various parts of the world. And UK is gradually changing that stance, which I do commend the government for it. But again, the decision is very much based on each individual officials, and that can lead to variations in protection. I do have certain reservations about that. So what I can do, this is not the end of my involvement. This is just a beginning, and I can assure you that I will continue to monitor the situation in the United Kingdom. And my mandate is also global. So if any of the workers in your own regions and countries are also going into places like North America, United States, and Canada, for example, where they have similar experience, then I'll be very happy to be communicated. And so I would certainly like to seek your cooperation in forwarding information so that I can take action. I just, as I say, came back from Canada last year, and they also have a similar temporary foreign workers program, which recruit workers in horticulture and other low-wage schemes mainly from Latin American countries. And I was also appalled to see a kind of similar treatment of migrant workers. So this is not just a pattern in the United Kingdom, but it happens in various parts of the world, United States, European Union countries, as well as my country, Japan. And we often blame, for example, the Middle Eastern countries for kafala system, which is also exploitative in nature. But it is important to recognize that even the developed countries like UK, Europe, in North America are reliant on these things. And one of the things I certainly would like to recommend is to end this temporary nature. And it gives, in all countries, including UK, should give more freedom to workers so that they can choose and leave without much legal complications. And I recommended this to a Canadian government, and I can say the same to the UK government. And also, it is a fact that there are certain labor shortages in horticulture and care sector and so on. And it is, for me, reasonable to open a pathway for more long-term and permanent residency. They do contribute enormously to the UK national economy and by paying tax and so on. And surely they are entitled to the same rights and entitlements as the UK citizens. And it is up to the UK government to enhance the rights of workers. So I do not want to go on too much. So I will end here. But as I said, this is the beginning, and I certainly look forward to working with all the stakeholders, particularly workers coming from different parts of the world. And my door is open, so please do get in touch, and I look forward to working with you. Thank you.
Brilliant. Thank you so much for that, Mr. Bagata. So far we just have one question, which I'll put to you, and I do encourage anyone else who may have a question to put it into the chat. But this question asks if you could discuss at which point the point of expedition common in the UK. So is at which point the exploitation in related to debt bondage is taking place for workers in the UK? So is the debt bondage, for example, emerging from local recruiters or in the country, or recruiters in the country of origin, or from the recruiters that facilitate the transit, or potentially from the employers that demand fees / reimbursement, or all of the above? So if you could maybe explain how debt bondage relates to the person, both from the source and destination perspective.
Of course, I think that's a very good question, and I think the answer is all of the above. And the workers really should not be paying a huge amount of money. My understanding is that the fee is about £250 to apply for this particular visa. But I received the allegation that some workers are paying as high as £3,000 or $3,000 just to get to the UK, and I think that's absolutely a deception, and that shouldn't be the case. And unfortunately, many recruiters are deceived in countries of origin. So many of these scheme operators may have affiliates in countries of origin, and according to the information I received, and many of these workers also actually went into these countries and explained these things to them. So that kind of suggests some of the complicity in many of these scheme operators in that type of arrangement. So that bondage happens when even before start working, they are already in debt because they have to pay a large amount of money to get to the United Kingdom. And in the end, in theory, they should be getting receiving at least a minimum wage, national minimum wage in the UK. But I also heard the instances of like underpayment, no over time payments and so on. And there may be deductions, for example, for living in accommodation and things like that. So at the end of the day, the money that they receive may be much less than that they have been promised. And that is an issue. And then by the time they pay their debt, they have no saving whatsoever. So that means they cannot send their money back to their home to support their family. And that continues until the end. So this is what makes it even more, these workers even more vulnerable, because that leaves like agency, autonomy out of their own workers. But I think it happens in countries of origin, it happens in transit, and it happens in the United Kingdom. So there are certain individuals benefiting illegally from this practice, and I feel I express my serious concern over that type of practices.
Brilliant. There's a couple more questions in the chat, but I'm aware we're slightly over, so I think we can answer some of them in the panel at the end. But one which may be of interest to you specifically, Mr. Bagata, is what kind of responsibilities or I guess punitive measures arise for states who do not comply with due diligence duties regarding trafficking and modern slavery? So is there any recourse for states who do not comply to obligations?
Sure. I mean, the due diligence is quite important. The business and human rights. In the United Kingdom, we have Modern Slavery Act, but that doesn't oblige these companies to implement human rights due diligence. And I have a reservation about that. I made myself quite clear that stronger form of due diligence is necessary. So the European Union just passed that directive obliging companies of certain sizes to implement due diligence, and failure to do so can result in punishment, fines, and other measures. And I do believe the UK should be considering that, obliging employers in horticulture and beyond to ensure that that happens. And so that is one of the difficulties: lack of enforcement and lack of a compliance regime, and that is one of the weaknesses in the UK, and that I think should be addressed. And I will be communicating to the government on an ongoing basis.
Brilliant. Thank you. If there are any more questions for Mr. Abagata specifically, and then maybe please put them in the chat. If otherwise, in the interest of time, we might progress to the next speaker. Okay, I will then send, I'm sure everyone sends their sincere thanks to Mr. Abagata to come and explain that and to talk through this. It was a very interesting talk and very interesting to hear. And I'll now move on to our next speaker, which is Lucila Granada from Focus on Labour Exploitation, who, as someone Mr. Bagata mentioned, have done some really excellent work recently, publishing some really great evidence and reports in this area, for which the whole of civil society in the UK is extremely grateful. Lucila Granada is CEO of Focus on Labour Exploitation, a research and policy organisation challenging and transforming the structures that put workers at risk of labour exploitation. Prior to this role, Lucila served as a director of the Latin American Women's Rights Service, a feminist organisation providing support services and campaigning for migrant women's rights. She was chair of the Labour Exploitation Advisory Group, a trustee at Flex and Ban Network, and advisor to the Shiva Foundation. Lucila also founded and led CLA UK, a coalition of Latin American organisations campaigning for ethnic recognition and improved access to health and labour rights. She is currently board member of the Global Alliance Against Trafficking in Women and chair of the IRMO, an NGO based in Brixton, and she holds a PhD in migration and ethnic identity from Aston University. And she's here to talk about the work that Flex does, really important work that Flex does addressing forced labour, and to give an overview of forced labour in the UK horticulture investigations carried out and their recent publications and findings. So Lucila, hand over to you. Thank you very much.
Thanks very much, Jamie, and to Libera for organizing this session, which we know is also only part of all the work that the Libera team is doing in support of the Latin American workers that colleagues have already referred to. So yeah, I'm here representing Flex, which stands for Focus on Labour Exploitation, and as Jamie mentioned, we work to address, to end labor exploitation by addressing the systems and structures that make workers vulnerable to abuse. And by that, what we mean is that we work to identify the conditions, the role that government plays, and the corporate practices that enable or allow exploitation to happen. So I will present some of the main findings that we've, the main issues that we've identified through our research in this sector. But I was also asked to give you a sense of the work we've done so far in this area. So to start, I'll share a bit about that with you. The main, I guess the most significant amount of work we've done has been on the research side. We've been looking into the situation in this area, regarding temporary migration programs and the risk created by temporary migration programs since government mentioned or announced the intention to introduce this scheme. So we're talking about 2018, 2019. And then after the scheme was launched, 2 years after the scheme was launched, we published an assessment of the risk of human trafficking for forced labor on the scheme. This publication was based on 84 surveys, 62 interviews with workers that we reached in an area in Scotland through conducting outreach. This is also, I guess the context to this is that there is very limited data as to where the workers are located. So it's very difficult to find data and reach out to workers. And this work we've done with an organization in Scotland called Five Migrant Forum. For this project, research looked into the ILO framework of indicators, and we used that framework to assess the level of risk. And finally, we launched this year a series of publications that I'll speak about in a moment. But aside from that, we've also been advocating for changes on the scheme. And this has involved engaging with industry stakeholders, that's including labor providers, farmers, retailers. We invested a significant amount of time in this engagement and joined an industry-led task force, which we've unfortunately had to leave to be able to focus our resources on the priorities we had identified for workers. We then co-founded, alongside other organizations, the worker interest groups, which is a joint advocacy group that where we coordinate with other NGOs and other organizations precisely to look at the priorities from the workers' perspectives. And of course, through this work, we still do work with industry as a joint coalition. And then finally, I should mention, we've also conducted as much government engagement as it's been possible, but avenues for this have been very limited. So overall, we've been working on this issue since the seasonal worker visa scheme was announced. But unfortunately, as I believe Jamie has already mentioned, what I have to say is that not much has changed on the scheme to address the issues that we've highlighted back from the beginning. So with this gloomy introduction, I will share with you some of the key findings from our latest research, which is based on a sample of over 400 workers and 15 stakeholder interviews. There's a series of publications that we published in this past few weeks. So the first one is called Bearing Fruit, and in this one we looked into the making the recruitment process fairer for migrant workers. And there are two key issues that to highlight in relation to the recruitment. One which has already been mentioned, which is debt. The vast majority of the workers that we were in touch with took out a loan to come to the UK. And when I say vast majority, I mean 7 in 10. That is 72% of the sample. And the costs for workers that we include here are the flight costs and visa fees predominantly, but there are also other expenses that are linked to migrating. The average cost that we're talking about is around £1,200, although there are significant variances across nationalities, meaning there are some national groups that are having to face much higher amounts. The other issue to highlight is that workers are coming in without knowing what they're getting into. So what we found in relation to this is that a large proportion were given a contract in a language they didn't understand. A large proportion were not given a contract that in a language that they could understand, either before or on the first day of work. And this is 2 in 5 workers. And 1 in 4 said that they had received no information on the transfer process, which is key, as we will see. Then in terms of the working and living conditions, I would refer to you to the latest report that we published that is called Not Here for the Weather. And as that title might anticipate, the main issue to highlight there is pay. We had a lot of workers reporting a range of issues, a range of difficulties in receiving enough pay. These issues were related to high peaking targets that are difficult to meet. We had only 1 in 4 workers that were always able to meet these targets. And then, as you can imagine, that is leading to intensification of work and to some workers reporting constantly feeling exhausted. There were also issues of underpayment where the workers were not always paid for all the pieces that they picked. And then many reported receiving less hours than they expected, meaning that they were less able to recover the costs, pay back their debts, and essentially earn a decent wage. So, well, there were, of course, a whole other range of issues that are included in the report. Some workers spoke about a culture of humiliation, being punished for not meeting the targets, being shouted at, humiliated. A few cases where workers spoke about threats of deportation, issues accessing healthcare, not being able to take time off when they were sick, and so on. And importantly, accommodation was another area that we covered, and issues connected to that were cases where workers reported accommodation not being clean, not having enough privacy, not feeling safe in the accommodation. This was a striking one. Just over a third of the people surveyed said that they felt safe in the accommodation. That's 37%. And overcrowdedness, so not having enough space. There were multiple workers that reported living in overcrowded accommodation. Somebody referred to this as living like sardines in a can. And many workers spoke about sharing rooms, but also there was one worker who told us that workers were sharing beds at their farm. And finally, the ability to change the employer, which is a key mitigating element to mitigate the risk of exploitation, being able to leave the abusive employment. And this is an area that we cover in a report called Bound to Work. And there are 2 questions that should come to mind when it comes to considering this issue, whether people can change the employer. One is whether it's possible for workers to change employers. And whilst it is possible in the rules, all workers on the scheme are able to request a transfer. As was mentioned before, a significant proportion were not even aware that they could make these requests. So they weren't told about the system of transfers. And over half of the workers who had made a transfer request had this request refused. The other question when it comes to changing jobs is, can you afford to leave your employment, first of all? And we talked about debt, and the vast majority, 3 in 4, that's 76%, reported earning less than they were told they would earn. So these obviously impacted on their ability to pay back their debts, as was mentioned, and to really consider the alternatives of leaving unemployment. We heard also incidents where supervisors were denying people shifts as punishments for not working fast enough, or for talking to colleagues, or for going to the bathroom, or even for asking about basic details about their work. So each one of these 3 reports that I've mentioned, and we'll try to share the links on the chat. There's a couple of colleagues from Flex also on this call. that can also help respond to other questions. But each one of these reports includes a list of recommendations related to those different themes. But something that we want to make clear is that there needs to be a proper review of the scheme as a whole. There's a need to clarify responsibilities across different government departments, and also a need for more transparency around data, and for government to take responsibility over monitoring worker welfare on the scheme and not outsourcing this to third parties. We believe that introducing isolated measures without having a proper review of the scheme as a whole can actually lead to unintended consequences. And we've seen examples of this piecemeal approach in the introduction, for instance, of the requirement to ensure 32 hours of work per week, which can seem to respond to some of these issues, but in practice, it led to shorter contracts, to higher charges in accommodation, etc. So, yeah, I would say in terms of 3 key, am I okay with time? Maybe I can.
We're running a little bit over, so yeah, as speedy as possible would be greatly appreciated, but it's all very interesting.
All right, I'll just highlight 3 then in terms of recommendations. Addressing the recruitment risks would need to government should respond to the high levels of debt. This can be done, for instance, by removing the visa fees, which can potentially be an interim measure, but an immediate measure that government can take to help address the high levels of debt. Ensure that workers also are given information in a language they understand. This is a basic requirement. I don't know how many on this call would, move across the world without having a contract. In terms of transfers, there needs to be an independent, centrally managed application process for transfers with clear criteria for transfer requests. And finally, on safeguarding, really there should be basically giving options for workers to be able to leave abusive situations. So that's either through measures like enabling workers to switch sponsors without submitting a new visa application, or introducing a safeguarding visa to allow workers to quickly switch to a more open visa. So these 3 key recommendations are included in our call to action from the CISLA Worker Interest Group, which I mentioned before. This is the alliance with the other organizations working on the scheme, and we'll include the link on the chat so that you can have a look. Thank you.
So now next we will be moving on to our next speaker, Anushya Kulupana. Anushya is a Scottish lawyer working at JustRight Scotland, a leading human rights law charity in Scotland that uses the law to defend and extend people's rights. She's a legal specialist and an expert, having worked in the areas of human trafficking and migrant rights for over 20 years. Certainly doesn't look like it. Anushya leads JustRight Scotland's Scottish Anti-Trafficking and Exploitation Centre, which is the only specialist legal project in the UK that focuses on providing direct legal advice and representation to child and adult survivors of trafficking and exploitation in Scotland, regardless of nationality, gender, type of exploitation, and geographical location. Taking a trauma-informed, holistic and human rights-based approach to legal representation, SATEC works in collaboration with other anti-trafficking organisations to tackle injustice faced by victims of trafficking and exploitation and improve access to justice. SATEC also serves as a hub for policy training and research in the area of human trafficking and exploitation, and sits on a number of local, national and UK-wide advisory engagement groups, including non-governmental, public and governmental groups, to advance the rights of those who have experienced trafficking and exploitation at both a national and international level. SATEC's model of legal advice provision has been classed as a model of best practice by the Organisation for Security and Cooperation in Europe. And as an active member of the ATMG, I can attest to JustRight Scotland's amazing credibility in this area. And she's here to sort of introduce the work that they do very much on the ground and provide that really interesting insight. We are 15 minutes behind at this point in time, so we can maybe have to cut into the Q&A section a little bit, but we'd also just to give you a heads up. But I'll hand over now. Thank you, Anushya.
Thank you very much, Jamie, and thank you very much for that lovely introduction and trying to unage me as things go. I am going to share a little presentation. I hope you don't mind. It is something that is much more a helpful tool for me to stick to a 10-minute time scale. I just want to double check that everyone can see that. Get a wee nod from someone. Thank you. Okay. So, yes, I know that Jamie has already spoken a lot about what JustRight Scotland does, so I'll kind of move on to the specific project that I work in, and this is the Scottish Anti-Trafficking and Exploitation Centre. And this is, as I said, a very unique project that tackles a wide range of different types of exploitation, different client groups, and so just bear with me. Okay. Part of our work is that we are there to support and assist people who have experienced exploitation or treatment trafficking at any stage of their recovery journey. So that can be right at the beginning, whether someone has been recovered prior to being exploited, or can be towards the end when we're looking at different kind of remedies that that individual needs. Our work is trauma-informed and holistic and human rights focused. And so that means that the remedies that we provide are not necessarily all legally bound. We provide a lot of legal and non-legal advocacy, and we link in with lots of other support organisations. We also provide and run peer support focused programme for bringing survivors together in order to be able to share their knowledge and inspire and support other survivors in something that they're not that they are particularly expert in. So in relation to kind of exploitation in the horticultural sector, we've been working in this for quite a while. Initially our exposure to it was through EU nationals who predominantly made up the workforce prior to Brexit. And within that time as well, we were seeing that EU nationals were also experiencing exploitation, unscrupulous recruitment. However, the level of that was in some way minimized, and we would consider that because of the freedom of movement, freedom of choice that EU nationals had when they came to the UK in order to carry out the seasonal work. They would come and go, work for a season, etc. And when it came to the UK leaving the EU, many people either decided to just leave, or they became settled in the UK and have taken up other forms of employment and have established their lives here, and many are thriving. Now, there's the same issues that we see when in non-EU third country nationals being brought to fill that gap that has been left by the EU national workforce. And because of the way that the seasonal worker scheme is designed and administered, it really heightens the risk of exploitation and trafficking for this new group of people. It is really, really important to remember that there's a person at the centre of all this. Okay, person just like any one of us, just applying or wants to kind of apply for a short-term job to improve their situation, whether they need urgent money or whether they need something a bit more long-term. And it's also to understand the kind of background that a person will be coming from. And when we're looking at the current workforce, and majority is from the global south. It's also important to remember the image that the UK kind of exports, one of prosperity, one of wealth. And so this kind of misinformation can be used by the traffickers and exploiters to kind of gain that control of individuals, to convince them to sell their belongings, to sell their homes, to get into debt in order to pay really high visa fees, because it'll be very quickly that they'll be able to make that money back, and they'll be making more following that. Okay, so we see the kind of issues arising right from recruitment. You know, the labour providers, farms, they're sending all this kind of imagery of sunlit farms, happy workers, videos showing people picking strawberries, and that kind of deception continues. People will believe, people are trusting, they believe what has been presented to them in the official way, and then following that, once they are removed from their kind of safe base of their own country, they're then subject to even more exploitation within the UK, and within that, it becomes even more difficult for a person to kind of escape that and try to seek redress. We talk about legal rights of victims, and within this list, I'm kind of referring to different situations where a person may be identified as a victim of human trafficking, in line with kind of international standards, or other kind of status as someone who's been subject to serious exploitation. There are multiple frameworks in the UK that is supposed to protect victims from exploitation. There are multiple legal frameworks. There's employment law practices, and this can include discrimination, unlawful deduction of wages, health and safety measures. There's legal protection for victims of trafficking, domestic legislation across the 4 nations of England, Scotland, Wales, and Northern Ireland, that all criminalise trafficking and exploitation of individuals, and they have imposed very serious penalties. There is, as previously mentioned, the National Referral Mechanism, which is the framework that is designed to identify individuals who may have been trafficked or may have been trafficked to the UK or being exploited in the UK, in order to kind of bring for the provisions of the Council of Europe Convention on Action Against Trafficking in Human Beings. International protections, we have the European Convention on Human Rights, and you've got European Court of Human Rights jurisprudence, which prohibits slavery, servitude, human trafficking, forced labour. It protects people from inhuman or degrading treatment or punishment, the respect for private life, and that includes the workplace and employment. There's equality legislation as well that we have. There are employers' regulations, health and safety, licensing standards, common law protections, and importantly, the UK has this legal duty not only to punish and prosecute human trafficking, they must also place a spectrum of safeguards to ensure the practical and effective protections of the rights of victims of human trafficking, including presumed victims. So with all this kind of framework, we've got this. Okay. But why is it then that these laws, frameworks were all in place, but we're still seeing this increase of exploitation and trafficking of people in the horticultural industry in the UK? We see that in other industries, our work kind of spans a wide range of industries, but yeah, why are we seeing this particularly? Why are we seeing it repeated despite putting forward evidence time and time again? Why are we seeing that? Well, as we see, there's not enough safeguards and active oversight from the process from start to finish by the UK. There is no oversight by the UK government to assess practices in source countries to see if they comply with UK standards and are lawful or ethical. There's no responsibility that seems to be taken in the actual practical effects and processes taken forward by the UK government in order to protect people who are coming to the UK, in order to support the UK economy, and in order to work for UK employers. It is extremely difficult for workers, as you've heard already, to know that they have rights, that they have these legal rights, they have these protections, and even if they do find out about it, they don't know who they can reach out to. And even if they do know who to reach out to, for example, we see people reaching out to their embassies and consulates. More often than not, they're getting brushed up. They're not. It is by random happen chance, by people like Carolina reaching out all the way from Chile and contacting us and contacting different organizations to see who can help these people who are in the UK. If someone manages to escape a farm, for example, and we've seen this, there just isn't the system in place to provide them with that crisis support, accommodation, and money that they need to rest and recover from what's happened to them, to be able to start assessing their options in a informed way, calm way, with that support and feeling safe. Instead, it seems like they're coming, out of the frying pan into the fire kind of situation. Yes, we have the National Referral Mechanism. It's supposed to give access to these resources, but the decision making is lengthy. It's increasingly being reduced, the access to the decision, the many errors that are made in decisions, and therefore these need to be challenged. The system now demands a lot of information from workers, which they may not be privy to in order to even get that initial identification. And during that period, while that's happening, there is nothing that's picking up that process. There is nothing in between that is there to support the person. So how is it that we're able to then kind of encourage individuals to come forward? How are we able to kind of gather that evidence and support people to be able to access justice from the farms, from the labour providers, from the UK government, who's failed them and failed to protect them and to meet their duties as is required by international law, domestic law, and just ethical and moral common sense. Legal representation is also an issue that we have. Yes, people have access to the right to legal representation, but you need to find a lawyer. You need to be able to find lawyers who know what they have the specialism in this area, who are able to take on that case and support the person, who are accessible easily, who know employment law, who are able to kind of have enough legal aid provisions, which is, you know, we can see it's a very underfunded legal sector now in the UK, all across the different nations. Criminal justice processes, civil claims, investigations, you have all these remedies, but they take time. They need, again, the lawyer, they need investment, and people just want to move on and become disillusioned by the lack of support. They are disappointed in the system that they come to face with, going from a system of abuse to another system that is not there to support them. They want to return to their countries. They just want to forget about what's happened and who blames them. And so for the employers and labour providers, it is of little consequence, really, from their practices, because systems in place just don't take into account the workers' rights and the particular circumstances of victims to make it effective in holding the perpetrators to account. People are responsible along the way, but they are not held accountable. And it is only because of people such as Carolina, who has been persevering with this, that we are getting to even this point of this webinar, which is an amazing thing. And it is shameful for the UK, and it's shameful for us working here or being citizens here, that it has to be someone who is in Chile who is pushing all this, and not us being able to have that system put in place together to be able to actually help all the people that we are seeing and that we really do want to support. Other ways of the way that companies can kind of move away from this responsibility for this, we saw very publicly advertised the exploitation, publicised the exploitation of Nepalese workers in this industry, okay, through debt bondage, lots of issues there. What did? They just stop recruiting in those countries, move to the next group, okay? But there's a whole wealth of vulnerable people who are needing jobs, who are easy to recruit and who are easy to exploit. So essentially, the whole system, ineffective, compounds the harm that people experience rather than actually protecting them, and it actually does allow for exploitation to continue. What we do need, as has been said already, is a really meaningful review of the whole system and put into place all those proactive monitoring and enforcement mechanisms. Like, be serious about their duties and international law, and be serious about the rights of individuals who are doing all they can to contribute to the UK economy and are working really hard in very difficult jobs, and just deserve, you know, all the respect and support that they should get. Thank you very much.
Thank you so much, and it's good to hear all that, especially from someone who has got such a strong track record of winning really good results for their clients. So thank you so much. Our next speaker will be talking about forced labour and labour rights, and it'll be Claire Marcel. Claire is head of legal at United Voices of the World, a member-led direct action anti-racist campaigning trade union that exists to support and empower the most vulnerable groups of precarious, low-paid and predominantly BAME and migrant workers in the UK. United Voices of the World was founded in January 2014 by a group of cleaners from Latin America, working with a few volunteers from street corners and cafes for the first 3 years. Since then, they have welcomed over 10,000 workers, which is really amazing, into the union from over 100 countries. Through strikes, occupations, blockades and campaigns, they have won tens of millions of pounds in improved pay and benefits for the UK's invisible army of low-paid workers. UVW is pioneering the fight against outsourcing in both the public and private sectors, and is the first union from over 100 countries, first union in the UK to end this practice in both higher education at the LSE and the NHS at the Imperial Trust, St Mary's and Great Ormond Street Hospital. They have also taken on subcontracting and discriminatory impact to court in an unprecedented legal claim at St George University, Royal Parks, and the Ministry of Justice, which could change the world we live in for good. So, really punching above their weight and really doing some amazing work. So it's great to be able to hear from them. So Claire, I'm very happy to pass over to you.
Thank you, Jamie, for the introduction. So instead of talking about the wider issues of the exploitation and the conditions of workers on the seasonal agricultural worker scheme, I'll talk about the specific case of some workers who've approached us last summer and how UVW has been trying to support them, bringing claims in the employment tribunal against their employer. So the case has already been widely reported in the media, specifically by the Bureau of Investigative Journalism and The Guardian, but I'll give a brief outline of what's happened. So a group of workers from Latin America have been recruited in Chile by a farm called Haygrove to pick cherries in the UK. And they attended a recruitment meeting organised by employees from Haygrove, where they were offered advance payment of the return flights. And they were told that the flight would not exceed $1,000, that they would make earnings of £500 a week, that the accommodation fee would be deducted from their earnings, and that they would have to pay for their visa application fee. So in the period between March and June 2023, the workers were in communication with Haygrove, attended appointments at the consulates and paid for their visa applications and signed various forms until they were sent their flight tickets to the UK. And in June, they travelled to the UK. They were taken to the farms and campsites in Hertfordshire and housed in caravans. And however, because of bad weather conditions, some of them were not offered to start work until about a week to 12 days later. And they received no pay during that time. They were offered loans from the employer for food and other essentials, but they were not paid. And when they were started working, they would get up every day to board a bus around 4 a.m. for a 90 minutes bus journey to the field. They would work picking fruits until late afternoon, then spend another hour and a half on the bus back to the campsite. And the 3 hours spent on the bus journey every day were not paid. In relation to their work picking cherries, they were instructed to pick as much fruit as possible, and their performance was color-coded. They were given a color of a green, yellow, or red, depending on how much fruit they'd been picking. And those with highest performance would be allocated more shifts and given extra hours. They described no adequate toilet facilities or drinking water on the fields. And they also talk about being shouted at by supervisors and having differential treatments between Latin Americans and Eastern European workers, with some given rows of trees with more fruit, given higher performance scores, and therefore being paid more. So within about 3 weeks of working, they received an email from the employer with a flight bill of £1,500 to be repaid within 6 weekly instalments of £250 on top of the weekly deductions from accommodation and transport. And after receiving the flight bill, they submitted a grievance and went on an unofficial strike and refused to return to work. Then a person from HR came to visit them on the campsite, threatened them with dismissals and cancellations of their visas, after which some of them left the farm, having earned a little more than a few £100s. So they made their way to London and then been taking their complaints forward, including to us at UVW, and we've now initiated legal action, trying to help them recover some of compensation from the employment tribunal. And we are arguing that Haygrove has made a range of employment breaches, including unlawful deduction from their wages, race discrimination, and detriment for having made a protected disclosure. So now I'll just focus on the issues of the wages and how the specificities of the seasonal worker schemes limits the options in terms of avenues for recovering those wages. So the structure of the scheme means that employers can bring workers from thousands of miles away for short-term employers, whilst the workers have to bear the cost of the flight, the visa, and the accommodation. And the visa conditions, as Lucila has said, limits the labour market options of the workers. So it's the condition of their visa that they remain employed by a specific sponsor or within a specific list of approved employers and cannot take up any employment. Otherwise, they lose their right to reside in the UK and they become vulnerable to deportation. And also in practice, it's very difficult for workers to transfer to another employer, and it's not really something they can do independently, being people who don't necessarily speak English, who don't necessarily have any networks here in the UK. So this means that there's very little incentive on the part of employers to offer good working conditions. And that's a situation that is conducive to abusive practices and debt bondage. So as already been said, the UK government changed its policy last year, and the rule is now that workers on the scheme are guaranteed a minimum of 32 weekly hours. So on papers, workers are entitled to be paid at least 32 hours per week, at least at the national minimum wage rate. But the rules do not specify that the worker's contract has to start from the date when they arrive on the campsite or on the farm. So what Haygrove did was to push back the employment start date, withholding wages until the weather improved and until their demand for labour increased. And their position in relation to the claim for unlawful deduction of wages is that the employment contract started from the first day of work, and therefore that they were not obliged to pay the workers until they started working, and they do not owe them any wages for all the time they spent waiting around stuck on the campsite. So we're arguing the opposite, that the employment contract started from the first day and that there was an obligation to pay the wages. Other potential obstacles involve derogation on the legal obligations of the employers in the agricultural sector to provide the contractually promised hours. So specifically, there's a Regulation 21 on the working time regulations. There are different provisions that allow an employer to require an agricultural worker to work without breaks or more designated hours per week, or to not work if there's something out of their control, for example, weather conditions or crop issues. So we can see that legally, workers seem to have some freedom to regulate their workforce and not pay workers when there is a reduced demand for labour. So on the one hand, they have pretty limited legal obligations to provide work, and on the other hand, workers have very constrained labour market options because of their visa conditions. So given the current states of the employment protection in the UK, we can see that there's very kind of limited obstacles in terms of what's possible within the employment tribunal as a way to get redress. So that's it for me. Thank you.
It was really great. Thank you so much. And also very excellent brevity. So very appreciated. That's really interesting and really important to hear those direct cases. So thank you so much for sharing those. So our next and final speaker is Carolina Rudnick, who is also the fantastic organizer of this event. So huge thanks for that as well. Carolina is co-founder and president of Libera, which is a Chilean non-profit organization that works in prevention and combat of human trafficking and forced labor, and that provides legal aid for victims and advocates for strong regulations, effective enforcement, and remediation. Carolina is a lawyer from the University of, I'm probably going to murder the pronunciation of this, so I do apologize in advance, Concepcion, show my French side, holds a master's in the criminal justice policy from the London School of Economics, and is a Fulbright Hubert H. Humphrey Fellow, specializing in human trafficking, corruption, and international human rights law from American University. Pardon me. She served in the Department of Organized Crime at the Ministry of the Interior and Public Security of Chile as the executive coordinator of the Intersectoral Table on Human Trafficking and its National Action Plan from 2013-2014. From 2016 to 2018, she directed the International Affairs area of the Financial Analysis Unit, UAF, where she led the development of the second national strategy against money laundering and terrorist financing for 2018 and 2020. And in 2022, she served as head of international relations at the Ministry of Women and Gender Equality of the Government of Chile. She teaches courses on money laundering, human rights, due diligence, and human trafficking at various universities in the country, and she is currently consultant for the Inter-American Commission of Women. So just a couple of qualifications there. And I can also say from ASI, Libera were absolutely instrumental in the passing of the corporate, I can only ever by its inaccurate corpus Sustainability and Due Diligence Directive, which passed this year, and they were really sort of instrumental and effective in that campaign, with a lot of their input being published in the European Commission's DV and just generally doing some great work. So yeah, very excited to hear from Carolina on this issue.
Thank you very much, James, for such a lovely and generous presentation. And thank you everyone for attending this seminar. One of the things that we usually hear from victims and from practitioners is how we don't listen victims and workers enough. So I will start my intervention by sharing with you a message sent by one of the affected workers. It's just a couple of minutes. The message is in Spanish, but I will share with you now on the screen. I don't think I'm actually sharing. Let me just, okay. There we go. So I'm just going to share her words. Okay, I think you can see the text, right?
We can see your whole window, but the text is quite not actually coming up.
Okay, let me just try to make this better. Let me see if I can. Okay, let's see if this works now. Here it is. I think you should be looking at it, right?
Yeah, we can now see the text.
Perfect. So I'm just gonna put play on her words. This is just an extract of her words, but I think it goes straight to the point that we wanna stress and raise in this webinar today.
¿Qué hay de ellos? ¿Qué hay de ellos si no cumplen el contrato? O sea, nosotros nos ven como cualquier cosa, nos veían porque sí, se les reían, nos veían, se reían, no nos hacían caso. Igual cuando hablábamos en el momento de la huelga, con los encargados o con los jefes se reían y nos daban vuelta y vuelta el tema, simplemente no nos hacían caso, como si nos hacían ver como tontos, como que nosotros éramos los del problema, que exagerábamos las cosas, pero no, nosotros teníamos claro lo que estaba pasando, porque nuestros derechos han sido vulnerados y las cosas han pasado aquí en Inglaterra, han sido vulnerados, violados nuestros derechos, discriminados, y esto es injusto todo lo que está pasando. Yo les digo, autoridades, a todos los que me van a escuchar este audio, que hagan algo al respecto, porque ya estoy cansada de que las personas solamente me escuchen, de solamente contar y de que no se haga nada al respecto, porque esto no puede ser, no puede ser. Yo he trabajado en otros lugares, he trabajado en Chile, yo soy boliviana, yo trabajo en Chile, y en Chile no ha sido así. Ha habido situaciones en las cuales he pasado, pero había siempre una solución, siempre hubo quien me escuchase. Pero aquí no. Todo el tiempo nos tomaron como chiste, como cualquier cosa, como un número, porque los trabajadores solo somos un número para ellos. Entonces no hubo cambios, no hubo garantías, por los cuales yo me tuve que salir. Yo me enlisté en una lista para salirme. Y cuando yo salí de la granja, y no salí, no es que me escapé, me salí. Y me salí hablando por la oficina. Yo me salí comunicando de recursos humanos. Y nunca me llegó el boleto. Yo vine a esperar mi boleto y nunca me llegó. Y cuando yo llegué aquí a Londres, me fue otra cosa que tuve que vivir. Fue muy difícil, demasiado, porque tuve que buscar a las personas para que me escuchasen y se haga justicia por todo lo que me pasó, por todo lo que pasó con mis compañeros, porque no solamente fue para conmigo. Entonces tuve que buscar a las personas, tuve que contar una y otra vez, en que muchas personas me decían que eso no es nada grave. Siempre veían la gravedad, pero no veían en lo psicológicamente, cómo nos había afectado, cómo me habían afectado psicológicamente y tantas cosas. Y que yo estaba sin dinero como para tomar un vuelo y regresar a mi país. Yo estaba apenas con 100 libras y yo tuve que pagar mis alojamientos y todo, y yo estaba casi sin nada, estaba con 5 libras después en mi bolsillo, casi sin nada. Tuve que ayudar a amigos para el cambio de un plato de comida. Entonces yo tuve que buscar a las personas adecuadas para que me escuchasen y se haga justicia, pero yo digo hasta ahora, no hay una respuesta, claro. Solo se ha hecho un caso omiso. Yo digo que hagan algo las autoridades, que se investigue todo y que se haga algo, que haya cambio en el sistema, de que esto salga a la luz, depende de las autoridades, porque de nosotros ya está, ya lo hicimos, ya está, pero ahora depende de ustedes de que se investiguen, de que esto lo saquen a la luz, de que esto lo pongan un fin o que detengan todo esto, porque esto va a seguir y no soy la única persona. Yo he estado leyendo y hay muchas personas que han pasado en este país en diferentes tipos de trabajo, diferentes tipos de ámbitos de trabajo, campos laborales, y no puede ser que esto siga pasando. Y es triste ver compañeros, compatriotas, amigos que sigan pasando en otros campos laborales. Y esto debería de parar, investigarse a profundo lo que nos pasó, investigarse, interesarse, porque esto no puede ser. Y depende mucho de las personas, de los que pasaron, de que esto se detenga y de las autoridades. Ya no permitamos acciones hostiles, ya no permitamos la esclavitud moderna, ya no permitamos la violencia, la vulneración de derechos. Para eso hay leyes, hay reglas, y esto no puede ser.
So as my colleagues Anushya and Claire explained regarding the case, this case was discovered because 2 Chilean workers escaped from the farm, traveled to Scotland to see to meet some acquaintances, and that is how JustRight Scotland on their side and us in Chile got to know this case. Later in London, workers reached out, United Voices of the world, and you have heard here and regarding what's going on. Just to give you a little summary of what is actually happening right now. So we have a criminal investigation going on in Chile regarding trafficking in persons for forced labor. We have a different system in comparison to the UK. Reports and complaints of illicit activity go directly to a prosecutor, and the prosecutor gives orders to the police or potential labor inspectors to do the different proceedings. So it was a surprise for us to see the UK system and understand that it's GLA or it's the police who investigate, and it's just in a later stage where potentially Crown Prosecution Service could operate. By listening to our client's statement and message, I think it's important for you to hear it in Spanish, because I hope that you could feel the emotion, the points she highlighted, and the intense sense of unfairness and injustice in what happened. And the interesting or the most remarkable thing about modern slavery as a crime, be it forced labor, be it human trafficking, is that we are talking always about power dynamics. So we're talking always about the lack of reciprocal recognition of fellow citizens as people with free and equal, worthy of dignity and respect. There are 2 things that I would like to comment, and in that respect, the communication of the special procedures of the UN is crucial for the current legal proceedings taking place in both countries. Because on the one hand, they stress the presence of clear indicators of the crimes that we're talking about, which is always something which is always a huge challenge in criminal justice policy, just recognizing the crime. And it's important to have such authorized UN representatives reinforcing that discovery on the one hand. And on the other hand, it's important to the communication, it's crucial to reinforce the two main concepts here, the duty to protect from the part of the state and the duty to respect from the part of companies. Regarding due diligence from the part of the state, what this case, the details of the communication, what Flex findings have discovered, and in the experience of United Voices of the World and JustRight Scotland, what we're seeing here is how discriminatory stereotypes are harming detection and investigation. Basically, what we are seeing, and it's sad, but this is happening all over the world. This is something that's also happening in the Chilean criminal justice system. The victims of forced labor, victims of human trafficking, are always considered from the part of the state, unless it's a case full of humiliation, physical restriction, almost torture thresholds. There's always this distrust from the state, thinking about secondary gains. And by hearing the statements of the workers, you can see that nobody who in its sane mind would create artificially a situation of this nature just for potential secondary gains. That is something that we need to make disappear in the criminal justice system. One other thing that I would like to highlight, and this is important for the UK system and also for the Chilean system, and from the words of the Special Rapporteur, I would say that it's something that we need to deal worldwide. Criminal justice system has a depth with connecting different legal regimes, connecting different laws, connecting social sciences. Human trafficking and forced labor requires to think in terms of patterns, dynamics, and typologies. We have incredible amount of reports. Just the reports mentioned by Flex today show clearly how these crimes are taking place, and we still see the criminal justice system completely shocked with these cases, not understanding how patterns and indicators are present in real cases, and therefore we just need them to acknowledge the reality of the evidence that is being shown. And finally, regarding the due diligence from the part of the state and their duty to protect, what the most, in our opinion, one of the most terrible things that we're facing is that the system is not believing the victims. And we cannot stress that enough, because that is a huge failure from the part of the state. In that respect, it is really great to be coordinating with different NGOs, also with journalists, and making possible, for example, the communication issued by the special rapporteurs. On the part of due diligence from companies regarding the duty to respect human rights, I invite you and I urge you to read the responses made by Haygrove Limited and Fruitful Jobs to the communication of the special rapporteur. Because in our opinion, those are confessions. What we are seeing is constantly companies replying, defending, excusing themselves by showing off what their policies say. But we don't need what their policies say. We can download them from their websites. What we need actually is to contrast that policy with the actual statements from the workers and with the actual documents that are in the criminal process. The other thing I would like to highlight regarding due diligence from the part of the companies and the duty to respect is the huge risk of outsourcing, the huge risk of subcontracting regimes. This is a phenomenon worldwide. What we are seeing is engagement between companies and recruiters. Recruiters' main duty is not to protect workers. Recruiters are merely firewalls that protect companies from complaints from the workers. And in order to pay respect to international conventions and treaties, we need to urge the state to make these duties from subcontracting companies to be a reality. Actually, what we're subcontracting together with these public policies actually what they show is the liability of these companies. Let's not forget, and I'm just going to finish with this because I don't want to take more time and leave some time for questions. Let's not forget that this year, a couple of months ago, ILO issued their estimates of profits regarding forced labor, and the current amount is $250 billion worldwide. So the unfairness, the injustice of the treatment of the situation and the experience of the workers we represent cannot be stressed enough. And we truly hope that this communication can trigger proper and robust action, not only from the part of the state, but also from the companies, and manage to obtain remediation from the workers. Thank you very much, James.
Thank you so much for that talk, Carolina. So obviously we are quite low on time. I don't know if anyone wants to or was able to stay for an extra 5 minutes or so. There's currently only 3 questions awaiting answers, so they should be answered relatively speedily. So one, Carolina, that I know that you'll be able to answer because you touched on already, is have embassies in the UK from workers' countries of origin gotten involved in cases advocating for workers that flee from their situation? Oh, you're on mute.
Thank you for the question, which is a very important question. We actually knocked the doors of all the embassies involved. I mean, that is Chile, Peru, Bolivia, Haiti. The level of responses was quite irregular. It's a good question because it allows me to highlight the fact that consulates, embassies are not really well trained regarding trafficking. So they dismiss complaints. In a first stance, they dismiss this complaint saying that it's a labor issue and they should deal with it with the local authorities. Just after the pressure of NGOs, embassies activated their response, and at least regarding the Chilean victims, the Chilean embassy managed to repatriate. But we're still waiting for responses from Peru, from Haiti, from Bolivia, because the level of support is very minimal. They can support repatriation, but they cannot guarantee that workers can continue with their legal processes, or they don't necessarily support them staying in London, and you can imagine how expensive. So there is definitely still a lot to be done with consulates, and we hope that this particular case, at least it was the case for Chile, can trigger the strengthening of their protection systems.
Thank you. There's another question in the chat, but it is in Spanish, and so unfortunately I won't be able to translate it, but I don't know if Carolina or Marcia, if you're able to take a look at that question. Another one that we could maybe answer very quickly, might ask if you can keep the answer to a max of a minute if possible, and I think it might be one for either Flex or JustRight Scotland, which was asked earlier, which is, has there really been a change, like a noticeable change in the nature of exploitation before or after the COVID lockdown in this area in horticulture? It's a slightly tricky question to answer, I'm aware of, as the seasonal worker scheme being rolled out aligns with the start, but I don't know if anyone wants to just quickly say an answer to that question.
I could probably go first. I would say it's very difficult to have conclusions and compare the situation of workers prior and post the COVID pandemic, mainly because of the point that I was trying to make also around data. The amount of data available is really difficult to really get a good representative picture. Also, there's limited data that comes from independent sources, although government's reviews already are quite concerning. What I would say is our first research, which was published in 2021, actually coincided with the COVID pandemic. And there were, of course, quite concerning issues that we identified at that point during COVID around workers. There was the whole system of workers being moved in groups or some measures to try and ensure isolation for those who had contracted the virus, but then also groups of workers ending up working in small spaces in spite of this. So a lot of issues with how the COVID measures to protect workers from contracting the virus were implemented, really. And then issues around accessing not only medical support during that time, but also even protective equipment, or being allowed to go to towns to buy food, etc. Some of these issues are covered in our first report, but happy to discuss separately with anyone interested.
Okay, thank you so much for that. I think that's a really good answer. And finally, just one last question, which I think probably will be best for you, Anushya, if you're able, which is what powers can be used to ensure that laws are respected and so the victims stop just being numbers. And then they followed by a rallying call for the end of trafficking and the more respecting of human rights. But the question really is what powers can be used to ensure that laws are respected at the moment?
We're in the ironic situation where you need law to enforce the law, and it's that vicious cycle. But as with anything, money talks. It is always follow the money, and it is when governments are required to pay compensation for breaching their duties, when you take it to a different level, and when challenge, that's essentially where we start seeing change. It is a sad thing to say, but that is how it is. And again, obviously, sharing beyond our bubbles, sharing beyond our knowledge, our groups, that we can potentially be echo chambers. It's about linking in as well. The big companies, the big retailers at the end, while they have to provide a modern slavery statement whenever they turn over £23 million, and that's where all this fruit, all these things kind of stop in this particular industry. And so it is by using their leverage and trying to engage those organizations or those companies to see if they're able to kind of exert their powers, and for them to maintain their reputation, etc. That's another way of trying to do that. But again, here in the rallying cry below that, no more victims of trafficking, and then the sad bit of human rights are becoming extinct. Yeah. I hope that did answer something.
Yeah, I think that's actually a really good answer. Yeah, thank you so much. And yeah, it's depressing, but it is true at the moment. Part of the core issue of all of this is that supermarkets and others are making huge amounts of money from it, and so it's very difficult to go against that sort of basic corporate power, especially in a country like the UK. So there are no more questions in the Q&A. There's one question, I believe. Carolina, do you know what the question is? Because I can't see it. So if we run over by 5 minutes, I think that's a fairly good reclamation of time, considering we got quite bagged out in the minutes. So if you want to stay for an extra 2 minutes, and we can end this question for Claire, which says, is the UK labour law robust enough to deal with these kinds of cases?
Thank you, Carolina, for the questions. My opinion is, well, first of all, no, I think there's the protections are quite sporadic. And an example of that is what I briefly talked about in my presentation. For example, exceptions to the working time regulations, so regulations in terms of taking breaks or the obligation to provide work, or the limitation on how many hours workers can be required to work. There's exceptions to that in the context of agricultural work, when it's for the reasons of bad weather conditions or crop issues. So we can see that farms can basically use this to just in the context of the work case that I've been working on, just not pay the workers. And also in terms of health and safety issues, a lot of the time it's health and safety executive, which has the responsibility for challenging employers on their failures to respect health and safety legislation. But it's another one of those bodies which is hugely underfunded. And another aspect which is not about the employment law protections on paper, but which is about the practical ability of people to enforce them. So it's access to justice is a huge issue generally when a lot of employment matters, claimants don't benefit from any legal aid except when it's discrimination, and especially in the context of agricultural migrant workers who are working in remote rural areas, who do not necessarily speak English, who are thousands of miles away from where they live. Finding a lawyer within the time so there's a deadline of a window of 3 months to submit a claim to the employment tribunal. So by the time you've left the farm, by the time you find your way to someone who could potentially help you, an organization, people who speak your language, who take the time to listen to your story and have the knowledge and the skills to help you, then you might have missed the deadline to submit a claim to the employment tribunal. So in practice, regardless of the legal protections on paper, in practice, it's very, very difficult for people to access justice.
Fantastic. That was, yeah, very, very comprehensive and brief, which is excellent. So thank you so much for that. So I guess I will, as we've run slightly over, we can run down the event. I want to just quickly take this opportunity to thank Carolina for organising this really important webinar, for also, while giving a talk, helping manage the Q&A section, and just generally being a superstar around the whole thing, and also more generally for the incredible work that you've done this area. And I'll extend that to all of the panelists. Thank you so much, not just for speaking today, but for being such excellent sort of examples of best practice in this area, actually. And yeah, we do have a lot to do as a collective of organizations, but at least we have a clear sense of the problems and a clear sense of solutions, and hopefully we can start making some real progress soon. I'll just very quickly hand over to the panelists if they want to make any last comments or anything before we end over, but if not, I think we can end this event now. And just once more, thank you for everyone for attending and listening and asking such good questions as well. Thank you, everybody.
Thank you. Bye.
Bye-bye.
Thank you.
Thank you.
Thanks. Bye. Thank you,
Bye.
Jamie.